Hi, I'm Joel Persinger. I'm the gun guy. Thank you very much for watching my videos. You have no idea how much I really deeply appreciate it. Please, if you haven't already, subscribe to our channel and we'll make sure that you get new videos whenever they come out. We'll send you a little note and let you know. Listen, I've got a whole lot of folks who have sent me emails, comments, and Facebook messages and tweets and everything else asking me to do some sort of a breakdown on Proposition 63. We had a very successful federal election in the sense that Hillary Clinton is not going to be our next president. So with Trump as our president, the hope is that the Supreme Court is a relatively safe institution, because if he appoints people from the list that he proposed, those are all really solid conservative justices, and we'd have a Supreme Court for the next generation that would be very pro-Second Amendment and very conservative and constitutionally oriented. So that's very positive. And then, of course, Republicans have maintained control of the House and Senate, so that'll allow President-elect Trump, when he becomes president, to get some things done, hopefully, for the Second Amendment to help us out. And so I'm excited about that. However, in California, in the very same election, it seemed like if there was a wild, wacko, crazy law that could possibly be passed by the voters, it was, including Proposition 63, which was the Gavin Newsom initiative. Earlier this year, in July, a whole lot of anti-gun laws were passed, Senate Bill 1235 among them, which dealt with ammunition, and we also have an assault weapons ban and some other things. And then Gavin Newsom, who is our current lieutenant governor, and he wants to be governor. Gee, I hope he never is, but that's an aside. Is trying to get his name out there and get some more name recognition. So he came up with this proposal that he threw out to California for the voters to approve. Well, and the voters, for whatever inexplicable reason, decided to do that. And what this video is about is a little bit of an explanation as to what that law is going to do in the state of California and what we have to do, if we choose, to comply with it. At least you know what the violations are going to be and so on. Now, the California Rifle and Pistol Association, along with the NRA and Gun Owners of California and some other organizations, put together a webinar on this very subject on the CRPA website. And I've got a link in the description so you can check out that webinar. That's what I did. I went and I listened to the webinar. Now, they're going to have a live webinar tomorrow. I'm actually recording this on Veterans Day. They're going to have a live webinar tomorrow, but I'm going to be out of San Diego County teaching, and so I won't be able to attend. But if you get an opportunity to attend, I believe it's on the 12th, which is tomorrow, and hopefully this video will get up today. Then go and check out that seminar. If not, make sure you check out the webinar. The link is right here in the description. All right, as I look at the initiative itself, here's what I've got. Lost or stolen firearms. Unlike previously, there's never really been a law in the state of California that required you to report a lost or stolen gun to the police department within a specific time, or penalized you if you didn't. But now there is. And those laws have been sent many times to the governor's desk and been vetoed every time, or he just let it die. But now this one has been passed by the voters. And so as of July 1, 2017, if I hold it out here, maybe I can see it better without my glasses on my face, you must report your firearm lost or stolen within 5 days. You have to report it to local law enforcement. You have to do it within 5 days of the date that you know it went missing, or the date that you should reasonably have known. I don't know what that means. And you know what? They don't know what that means either. The attorneys for CRPA and the NRA said that's really super duper vague. Who gets to decide that? Under what circumstances are you all screwed up now because you had a house, a second home or something, and you kept some guns in a safe there and you haven't been there in 2 months, and you go out there to visit your house and find out the place was broken into, the safe was broken into, and your guns are gone? Well, did that happen today? Did that happen last week? Did that happen 3 days ago, 10 days ago, a month and a half ago? You don't know. And so you call the police. And does some prosecutor somewhere start to prosecute you for being late because they say, well, these are firearms and you should be a responsible firearms owner and you should know where your guns are all the time. It doesn't matter where they are and what property they're in. You should keep tabs on them. You should have had some sort of a surveillance system, or who knows. And so, you know, this whole thing about reasonably should have known is just a way to nab you, if you ask me, because there's no way to know that. Anyway, that's the thing. 5 days from the date you know, or the date that law enforcement or the court or whatever decides you reasonably should have known, you have to report it to local law enforcement. Now, if you get the gun back for some reason. You know, you thought it was stolen, you forgot you lent it to your buddy Bill, and he calls you and says, hey, don't forget I got your gun, and you get it back, then you have to report that to law enforcement. So if you reported it stolen or lost and then discover that, no, it really wasn't, or you got it back in some fashion, now you have to report it to law enforcement within 5 days and let them know that it was no longer lost or stolen. Well, that's great from a law enforcement perspective. Lets them know they don't have to have to be on the lookout for it anymore and like that. But what prevents some gun Nazi in law enforcement or some local DA from saying, well, how'd you get it back? Where was it? Why were you so irresponsible and start hunting around for some, vague, obscure law to prosecute you on? Again, we get into this, nanny state stuff, and that's what this is. All right, there's exceptions to this law. I'm going to put them up on the screen for you, and they are law enforcement when acting in the course and scope of their duties, if they lose their gun while they're working, and if they report it then to their agency, they don't have to report it to local law enforcement. Armed forces, when engaged in official duties, when the gun is lost or stolen and they're involved in what they're doing for armed forces work, if they then report it to their branch of the service, they don't have to report it to local law enforcement. Federal firearms dealers, federal firearms licensees, importers, and the like, they have big requirements from federal and state law to report these things. And so if they do that, then they don't have to report it to local law enforcement. And you do not have to report guns lost or stolen if they were lost or stolen prior to July 1, 2017. Now, I don't know about you, but that's a recipe for for making up all kinds of stories if you want to. I don't know why they even write such things. First of all, the law is stupid to begin with, but if I can simply say, oh, I lost that gun in 2015. Didn't have to report it. Oh, no, that was stolen back in 2000. That was stolen back in January of 2017. Why didn't you report it? I didn't have to. See? So, how many different ways are there to make this law completely unenforceable? It's crazy. All right, now there are some penalties for this. They are misdemeanors the first and second time. The third time, then it's possible jail time. So, I'm sorry, I said that wrong. I apologize. They are infractions the first and second time, and then they're misdemeanors with possible jail time the third time and subsequent time. So the first time you don't report on time is an infraction with a fine of $100. The second time is an infraction with a fine, the wind's blowing here, of $1,000. And then the third and subsequent times are misdemeanors potentially and could land you in jail for 6 months plus a fine of $1,000 if they wanted to add the fine on there, or just a fine and no jail time, but one or the other or both. My question is that if I have 3 firearms stolen and I don't report it on time, is that 3 violations? Or is that just 1? Are they going to stack those? And now I'm facing a $100 fine for the first one, a $1,000 fine for the second one, and I might go to jail for 6 months and pay $1,000 on the third one? Or are they just going to get me $100 because I reported it on the 6th day or the 7th day? This is the kind of stuff that will drive you completely nuts. In any case, I'm going to put those up there for you so that you can see the fines, again, if you don't report your gun on time within 5 days of the day that you know it's missing, or the day that you reasonably should have known, whatever the heck that means, or for some reason you get it back and you don't report that within 5 days. These are the time frames, or these are the penalties rather. First time $500. The first time is as a $100 infraction. Second time $1,000. Third time misdemeanor potentially with a 6-month jail term and or a $1,000 fine. So basically they're making you a criminal because you were a victim. Okay, let's talk briefly about what needs to be reported. You have to report the make, model, serial number if you know it, and so on. So that's kind of standard. You got to tell them what kind of a gun it was and the serial number if you happen to know it. Here's the part that gets me, and I'm amazed. The statute actually says that in addition to that, you also have to report any, quote, additional relevant information required by the local law enforcement agency taking the report, unquote. So who determines what's relevant exactly? Is it relevant what time of day I thought it was stolen? Yeah, that's probably relevant. How did they get in the house, or how did they get into the car, or where was it stolen from? That's probably relevant. Did I see anybody hanging around my house early that day, or did I see anything suspicious? That's probably relevant. Where did you get the gun? When did you buy the gun? How long have you had the gun? How many other guns do you own? That's not relevant. And so I think this is so vague that there's an opportunity there for police to start asking questions that have nothing to do with the immediate crime at hand and could very easily have you incriminate yourself and you don't even realize you did it. And so you're the victim of a crime and they start asking you questions pell-mell here and you start answering them. And the next thing you know, you've said something that landed you in jail and you were the victim. So I would encourage that if they're asking anything beyond make, model, serial number, what time was it stolen, and have you seen anybody suspicious around, I would be saying, officer, I don't want to answer any further questions. I'd like to speak to my attorney. But here's the part that drives me wacko. You're a law-abiding citizen, you've been victimized, somebody has stolen your property, and now you have to hire an attorney so that after becoming the victim, you might have to just be scared of the police so you can defend yourself against possibly being prosecuted inadvertently for some oddball little crime you broke or a little law that you broke and crime you committed you didn't even know it existed. And it doesn't matter, but because you said something, the wrong thing to the cops, when they came out to take a report about your property which was stolen from you, you can find yourself in jail, fined, whatever, some violation of some other crime. That drives me absolutely bonkers, and it ought to drive you that way. This state is getting weirder and weirder by the day. All right, false reporting. False reporting of anything to the police has been a crime for as long as I can remember in California. You lie to the police about something, you report it, file a false report, that's a crime. Now, that's always been a misdemeanor as far as I know, and yet, and under SB 1235, which was the law before this thing passed by the voters, it was a misdemeanor to file, I believe it was a misdemeanor to file a false report regarding the loss or the theft of a firearm. But this law made it an infraction. Go figure. You know, the people who would really intentionally lie to the police, they're not going to get penalized much anymore. But the guy who's just an honest law-abiding gun owner who makes an inadvertent mistake, he's got to maybe go to jail for 6 months because he didn't report it fast enough. It's backwards. It makes no sense. All right, let's move right along here to large capacity magazines, which aren't large capacity, but that's what they call them here. I call them normal magazines, and the short ones that only hold 10 rounds, I call those neutered magazines. But nevertheless, for California and other goofy states like that, they're large capacity. All right, in July, the governor signed some laws into law the bills into law that one of which made large capacity magazines that hold more than 10 rounds, illegal to possess in the state. Now, prior to that, there was a ban on importing them, manufacturing them, buying them, selling them, and so on within the state. But if you already had them before that ban, there was no law against you possessing them. It was all about when did you get them and how did you get them. That's what it was all about. And so you were grandfathered in if you had them. And there's a lot of those in this state because people had them and you could take them to the range and use them and do whatever you wanted to do with them because they were legal to possess. But now, as of July 1st of 2017, they will no longer be legal to possess. And there is no grandfathering. It doesn't matter when you got it, doesn't matter how long you've had it. If it's more than 10 rounds, it is against the law in the state of California to possess it with no grandfathering. Now, under Gunmageddon, which were the laws that the governor signed into law in January, that was passed and signed back then, the possession of these magazines was an infraction punishable by a fine, like a traffic ticket, and it got more expensive the more of them you had, or the more times it happened. Proposition 63 makes possession of these magazines as of July 1, 2017 punishable as either an infraction or a misdemeanor. So somehow they get to make that choice. I don't know what makes that flip from one to the other. But a conviction of this now under Proposition 63 also, by statute, could result in you losing your firearms rights, even though it's not a felony. You could lose your firearms rights if you're convicted of it. That's nuts. I'm not moving. I know everybody says move, but I'm not going to move. I live here. I grew up here. I'm not going anywhere. I'm going to stay here and fight. But boy, if you want to move, I don't blame you. All right, ways to comply. I'll put these up on the screen for you. You can remove the magazine from the state of California. You can sell the magazine to a federal firearms licensed dealer. You can surrender the magazine to law enforcement for destruction. Please don't. And there may be a way there's ways for you to permanently alter the magazines, and I'm assuming, but I do not know, I'm assuming that that is legal. I've been told that that is legal, but now that Proposition 63 has passed, frankly, nobody's really sure. But those are the 5 options that you have that are legal. Of course, there's always the option not to comply, but keep in mind, if you don't comply, and you get caught, then there's a chance you might lose your firearms rights, and there you go. Now you're really kind of stuck, and they'll start chasing you, wanting to take your guns away. Of course, there are exemptions to these things, and it's the usual suspects, if you will. Law enforcement agencies, law enforcement officers, companies and dealers that sell to law enforcement, retired sworn law enforcement officers. Now they're exempt from the possession violation, but they can't go purchase them. They can't purchase them, trade them, sell them, or whatever. But if they already got them, then they can keep them. So if you're law enforcement, you're about to retire, I'd suggest you go out and buy a whole bunch of these magazines before you retire and get yourself a bunch of them, because once you do, you got them, but you can't go get any more. And you can't bring them into the state, because even though these laws are new, the other restrictions against importing, manufacturing, and so on still exist. And so if you go buy them in another state and bring them into the state and get caught, that's against the law as well. This does, and in addition to that, this law also removes the exemption that was there before for taking the magazine out of state and then bringing it back. There used to be an exemption in the law that was passed in July and previously, that if you had a magazine and you took it out of the state, and it was a 12, 13, 11, 12, 13, 14, whatever, over 10 round magazine, you took it out of the state, you want to go to a class or something, bring it back, you could bring it back. And you just say, no, I already had it already and I'm bringing it back. And they'd let you, not a problem. But now they've taken that restriction away. So now you're the retired police officer who can possess them and it's not a problem. You take your magazines you've had forever from the beginning of the time and you go out of state somewhere because you want to take a class at Front Sight, Gun Sight, Thunder Ranch, I don't know, pick a place. Or you just are carrying your firearm and you're going to go over to Las Vegas for the weekend or whatever you're going to do. And then you decide to come back into California. You can't bring that mag back. If you do, you're importing. Go figure. You already owned it. It was already in the state, but you took it out. Now you cannot bring it back. If you do, you're importing that mag into the state. That is a state crime. And if you get convicted of it, you could lose your firearms rights. What? Yeah, that's the kind of nonsense they got in this law. It's crazy. All right, let's look at ammunition real quick. First of all, just to define ammunition for you, and I want to make this really clear because I get a lot of calls about this. The ammunition, even in Proposition 63, is defined as the completely assembled cartridge. Reloading components are not included in any of these restrictions. It is the completely assembled cartridge, not reloading components. You can buy those all you want to, and you don't have to worry about this so far. I mean, I don't know what's going to happen after that. And that's the same in Gunmageddon, and it was also the same in Proposition 63. It does not cover reloading components. It does, however, create a straw sale violation, much like the straw purchase, straw sale violation with firearms. So if it's ammunition or magazines or clips for your M1 or speed loaders or components or whatever, and you sell those or provide those to a person you know to be prohibited from owning firearms or owning ammunition, then that is a violation now of law. It was not before, now it is. And this does not apply to just ammunition. It also applies to ammunition components. But this is the only part of that law that does have that requirement. So I'm going to put that up there so that you can read it yourself. Straw sales are a violation, not just of selling firearms in the state, but selling ammunition or ammunition components or magazines or speed loaders or any of those kind of things. That all falls into this weird straw sale violation now that did not exist before. All right, these are the requirements of the law, and then there's so much to this thing. As you can tell, I've got like 5 pages of stuff to go through. I'm not going to do it all in this video. I'm going to break it into a couple of videos because otherwise it's going to drive you nuts. But let me give you the requirements of the law and then a little encouragement at the end from the NRA and California Rifle and Pistol Association with some plans that they have. And then in part 2, which I'll do in a couple of days, I'll get you through the rest of this so that you know what's going on. All right, requirements for the ammunition portion of the law. Starting January 1, 2018, ammunition sales must be processed through a licensed ammunition vendor in the state of California. Private party transfers must also go through a licensed vendor, much the same way that private party transfers of firearms are supposed to go through a firearms dealer. The vendor may charge a fee for this, obviously. If you buy ammo online or have it shipped to you, there's a problem with that because as of that date, and guess what, all transfers have to be face-to-face. And so you're going to have it shipped to a licensed vendor, and that licensed vendor is going to have to do the background check and all that other nonsense, which we'll talk about in the next follow-up video, before you can get your ammunition, just the same as you would with a firearm. You cannot sell more than 500 rounds per year of ammunition. I'm sorry, you cannot sell more than 500 rounds per 30 days, every 30 days, to anybody without a vendor's license. And you're actually not supposed to sell ammunition, really, at all, unless it goes through a vendor. You can't even transfer a box of ammunition without it going through a vendor. Here's some exemptions, and then and this is a very interesting part, and then I'll cover the rest in the next video. Here's exemptions. Law enforcement agencies. Sworn law enforcement officers, although they have a problem a little later on with this whole ammunition thing. And if you're a sworn law enforcement officer, you might want to watch part 2. Federally licensed firearms dealers, ammunition importers, manufacturers, and so on. Persons on the centralized list of exempt firearms federal licensees. CNR collectors with a certificate of eligibility. How about that? Ammunition vendors. Consultant-evaluators. What are those? Well, that's me. People can send me stuff to evaluate on YouTube, to give my opinion and so on. So that makes me exempt if the ammunition, that's my understanding, if the ammunition is sent to me for that purpose. Target facilities and ranges and so on that provide ammo for people to shoot at the range, but the ammunition has to be used at the range, cannot leave the range. Persons who purchase ammo from a spouse, domestic partner, or immediate family member are exempt. However, the exemption that existed in the laws signed in July by the governor for hunting clubs and nonprofits have been removed in Proposition 63. So if it's a hunting club or a nonprofit organization about hunting or shooting or whatever, guess what? You're not exempt. How about that? All right, I'm going to cover the rest of this in part 2. Before I do that, though, and before I ring off here, let me read a statement that the CRPA, just part of one, that the state CRPA put out right after the passage of this law and right after the elections were over. And this is what it says. With the passage of 7 new gun bills in July that essentially duplicated Gavin Newsom's Proposition 63, Proposition 63 became somewhat redundant. Not completely so, but somewhat. So while still opposing the initiative aggressively, the Coalition of Civil Liberties partners, NRA, CRPA, Gun Owners of America, and so on, including the NRA, shifted some of their resources to fighting the battle that mattered the most. That would be the presidential battle. With our victory in the presidential election, successful legal challenges will now be filed against all these new ill-conceived and unconstitutional laws. And those cases will be heard by a new Supreme Court that will see these laws as the Second Amendment violations that they are. So, yeah, we kind of got shafted in California, but we won the national fight, and the battle is coming. And maybe we have a shot at turning some of this stuff over. It's going to have to be done in court, unfortunately, and that takes time. But I would say, hang in there, don't give up. Now check out part 2, I'll have it up in a few days. That will get you through the rest of this. There's several more pages of this nonsense. You do need to know what it is. If you'd like to check out the NRA and CRPA webinars, you can do that. Check out the description. Please like, subscribe. That's what this button is up here for. And whatever you do, be safe.